Hello, I'm Constitutional Attorney Katherine Henry, and today we're going to talk about 25 of the most common legal terms used in appeals cases. So make sure to check out this series, as well as our other series that we have on most common criminal law terms, most common civil terms, and most common general legal terms. So without any further ado, we're going to get started with those appeals terms. Amicus curiae, that means a friend of the court, and not in the sense that there's a friend of the court in Michigan that deals with custody and parenting time cases. This is one that is not involved as a party, but who intervenes in a lawsuit to volunteer information about a point of law to assist the court in deciding a matter before it. So when there were a lot of legal challenges to Governor Whitmer's executive orders in 2020, and those cases went from the Court of Claims to the Court of Appeals and then the Michigan Supreme Court, I participated as an amicus, filing a brief to argue issues from a different perspective than the original parties to the case. And there were a few other amicus parties as well, some arguing for the governor's executive orders and some arguing against the executive orders. But if you're interested in seeing what that looks like, you can go to my website and check out some of the information there and some of the videos. You can see the video where I argued in the Michigan Supreme Court as amicus, arguing against Governor Whitmer's executive orders in 2020. Appellant. Now, this is the person who is actually appealing a judge's orders or a decision of a lower court up to a higher court. Appellate court. This is the court that hears the appeal and reviews the decisions of the lower court, but generally is just looking for legal errors that happened in the proceedings below. They're not going to conduct an entirely new trial, and they're not going to relitigate the facts of the case. Appellee. The appellee is generally the person who won in the lower court, and it's the other party who is bringing the appeal. Now, sometimes you have people or situations where both parties kind of lost or both parties kind of won, but one party decides to appeal the part that they don't like up to a higher court. So it's not always one person won, one person lost, and so it's the person who lost who's appealing. But in general, you can think of it that way, is that the appellee is the one who generally won or at least won more of the issues at the lower court. Brief. The brief is the written argument submitted to the court by counsel, setting forth the facts and the law supporting his or her client's case. Caption. That is the heading of the document prepared for consideration as part of a court proceeding, showing the names of the parties, the names of the court, the number of the docket number or court file number, etc. Certiorari. That is an order commanding judges or officers of a lower court to certify the record of a case for judicial review by an appellate court. Circuit court is often the highest trial level court in a state, for example, such as Michigan, but sometimes it serves as an appellate court. So if you have a decision that happened in the district court, for example, in Michigan, and you want to appeal that decision, then you actually have to appeal it directly to the circuit court before you can ever get to the stages with the Court of Appeals or the Michigan Supreme Court. De novo, that means anew, to start all over again, essentially. So, for example, in Michigan, custody and parenting time proceedings start in the front of the court, and a front of the court referee essentially does their trial. They call it an evidentiary hearing, where all the issues are laid out before that magistrate or that referee, and all the evidence is presented, the testimony is shared, etc., the documents, the pleadings, all the arguments are made at that level. If either party, so then once you have that evidentiary hearing concluded, then the referee then issues their recommendation and report or their recommended order. If neither party objects within 21 days, then the circuit court judge signs that order and it becomes a binding order of the court. However, if either party objects within 21 days, then it goes to the circuit court. And instead of that being a typical appeal review where they're not redoing everything and they're just looking for legal errors that happened, in that situation, it is a de novo review. So that means everything starts all over again. So there will be a whole new trial in front of the judge. There will be witnesses and evidence presented. There will be pleadings, a trial brief, things of that nature, motions. So all of that will happen all anew in front of the circuit court judge. So de novo means a completely new renewing of the facts at hand. Dissent. This is disagreement by one or more judges with the decision of the majority in a particular court case. So you often hear of the majority opinion and the dissenting opinion. The dissenting opinion carries absolutely no weight. You can use it as a persuasive argument if that's the only authority you can find on point with what you're trying to say in your arguments. But if you're referring to a decision by the court, it's the majority opinion that actually carries the weight of being the precedent, whereas the dissenting opinion has no binding authority whatsoever. Due process of law. The fundamental rules that guarantee fair play in the conduct of legal proceedings. So, for example, the right to an impartial judge and jury, the right to present evidence on one's own behalf, the right to confront one's accuser, the right to be represented by counsel. So, a lot of appeals actually revolve around this concept of a denial of due process, that if somebody is denied due process, then the end result generally cannot stand. Exception. This is a formal objection to the court's ruling, which implies that the accepting party does not accept the court's ruling and will seek a reversal at a later time. In other words, it's the precursor to an appeal. If you don't properly object to something happening at the trial court level, then you are not preserving that issue for appeal, and generally you will not be able to raise that issue in an appeal. There are a few exceptions, very limited exceptions, such as subject matter jurisdiction, which can be raised at any time. But generally speaking, if you don't like something, you have to make sure that objection is clear on the record at the trial court level before trying to raise it on appeal later on. Harmless error. This is an error committed in the course of a trial that was corrected or would not have affected the outcome of the trial, and therefore does not justify reversal of the verdict on appeal. Inferior court. This is any court subordinate to the chief appellate court in a particular judicial system. So, for example, with Michigan, you have the Michigan Supreme Court. That is the chief appellate court in that judicial system. And the inferior courts are the probate courts, district courts, circuit courts, and even the Court of Appeals, also the Court of Claims. But if you're outside of Michigan, that concept really doesn't make sense. But it's a trial level court as well. Interlocutory. That means temporary or not final. And this term is very important because I've done several videos on the different types of appeals, so you might want to check those out. But interlocutory appeals are different than regular appeals because regular appeals are where essentially the case has gone all the way through from start to finish at the trial court level, and objections have properly been made along the way. And then one of the parties decides to file an appeal based on the outcome of the case. And because of the legal missteps that have happened to arrive at that bad outcome. Whereas an interlocutory appeal is an appeal that happens before the trial court is even done. So, for example, when I was wrongly arrested in 2020 on Election Day in Michigan while serving as an attorney for someone, I filed, that case took almost 2 years to dismiss, and I filed a series of interlocutory appeals because if it was just the arrest that was wrongful, then I would have essentially had to wait to appeal at the very end of the conclusion of the entire case. However, the prosecutor and the judge kept making legal errors that were severely detrimental to my rights. And the whole point of an interlocutory appeal, especially in the criminal context, is to say, hey, wait a minute, I shouldn't even have to go through the whole suffering through the whole nonsense of this trial that might take a year or two to get to a conclusion, just to have to appeal at that point. I should be able to appeal to the Court of Appeals, or I had to go to the circuit court first and then the Court of Appeals. But I should be able to file this appeal now because what's happening is improper and it's illegal. And the whole process by which it's all occurring is faulty. So that's an interlocutory appeal. Reply. The plaintiff's answer to the defendant's argument when a case is tried and argued before a court. So even with the pleadings that we just talked about, if you have, say, the plaintiff's initial brief, and then you have the defendant's brief, then the plaintiff typically is allowed to file a reply brief, which is much shorter, and it must be confined to the issues raised by the defendant or addressed in the defendant's brief.